Indian Evidence Act application बता दिया मैंने आपको. Oh, you must have understood it, isn't it? It applies to all the courts, judicial proceedings. The judicial proceedings are explained under the provisions of Section 2R CRPC. All the courts which are capable of recording evidence, and it doesn't apply to basically tribunals. It doesn't apply before the arbitrators. That is Section 1 um, of the preamble के बाद जो act है. 2 has been repealed. 2 was dealing with a situation earlier. The earlier acts under the Mohammedan law and the Hindu law and the English law, where the Evidence Act was being recorded, वो repeal किया गया है. अभी repeal से हमें कोई ताल्लुक नहीं, छोड़ दीजिए. Then interpretation clause में I dealt with the definition of the meaning of the court, which has been defined for the first time in the Evidence Act, which includes a judicial magistrate, all judges, person authorized to take evidence, but not the arbitrators. Under the Arbitration Conciliation Act, Section 19 check करेंगे. The arbitrator is not strictly, though they record, though they normally conduct trial as per the provisions of CPC and Evidence Act, but they are not bound to follow it strictly, because the Evidence Act makes it a very strict provision. You must have a certified copy, you must have a original document to prove it. Whereas the arbitrator will take also ordinary copy, newspaper report भी ले लेंगे. ट्राइब्यूनल के अंदर भी आप बता देंगे कि न्यूज़पेपर में देखो ये आइटम आ चुका है, the deficiency of service, consumer court will accept it. वो रिकॉर्ड पे ले लेंगे. Whereas civil court, where the application of the Evidence Act come into play, Evidence Act क्या कहेगा आपको? Please provide the source of the information. ये न्यूज़पेपर में जो लिखा गया है, it is not evidence. The reporter must come and depose before the court of law. From where did he collect the evidence? What is his source of knowledge? Unless he comes and substantiate, he will not become evident. Similarly, Section 161 CRPC के अंदर, a police officer has power to record statement of witnesses after giving you notice under 41A CRPC or without even giving notices. He has got vast powers. So the statements which are recorded by a police officer are not evidence. Please note that here, because that is why Section 162 says that here, the person who makes this statement is not required to sign the statement. Oh, statement is not binding. That statement becomes only evidence when, after the filing of the charge sheet under Section 173, which copy with the police officer files it after the conclusion of the criminal trial, and which copy is furnished to the accused person under the provisions of Section 207-208 CRPC, along with the list of documents as contemplated under Section 173, subclause clause number 5 and 6 and 7, 8 में वो document देने के बाद ही जब witnesses are produced before the court of law, a witness summons are issued under the provisions of Section 61, 62, 63 of the CRPC. Court में आके कहेंगे, and the public prosecutor, when he begins his trial, then he describes the charges, and the court will ask him, what is the nature of evidence you want to lead? The public prosecutor, you learned under the scheme of the CRPC, he will give description and narration of the fact to the court of sessions and to the net magistrate. वो description देने के बाद ही जब the court of sessions on the magistrates court in warrant tribal case and other cases, they will frame charges. The charges are not framed till the public prosecutor opens the inning. उसके बाद ही the court will comes into conclusion. The court also has a right to find out for recording, for framing of the charges, whether evidence of the witness is required to be laid or not. Similarly, under the Code of Civil Procedure, a civil court, after the completion of the pleadings in the CPC, plain and written statement होने के बाद, you know that here, the documents are introduced for the first time at the stage of the filing of the plaint itself under the provisions of Order 7, Rule 14 CPC. And the defendant introduces the document under the provisions of Order 8, Rule 1A CPC. All documents he must disclose to the court. And if he does not disclose these documents, he will be forbidden from using the same in evidence. And he is not required to, plaintiff or defendant can suppress at the moment, withhold from the court, withhold from the other side a document meant for cross-examination of the other side, which document is mentioned under section 145 of the Evidence Act, which I will explain to you, that is meant for cross-examination of the witness who has written the document, or for the purpose of contradicting the witness under section 145, or for the purpose of corroboration under section 159, 158 CRPC, or for the purpose of again impeaching his credibility under section 153, 154 of the Evidence Act. So these are the various stages, because just Evidence Act under you cannot say that yoga. These are the stages where the court will consider whether this is a court or not. So a police officer is not a court. Arbitrator, ये सब चीजें नहीं होंगे. Before the arbitrator, basically why? Because section 10 of the Arbitration Conciliation Act says that here any Tom, Dick and Harry can be appointed arbitrator by the consent of the parties. Isn't it? ऐसा कोई, there is no nationality is fixed here. Of course, every time you don't appoint Supreme Court or High Court judges who are competent to record evidence, and a High Court, Supreme Court lawyer who can do that. Sometimes even a contractor is appointed. Sometimes a person who is a layman is appointed. इसीलिए they are excluded from the purview of the court. They are not competent. Similarly, a police officer is an overzealous police person. I mean, a police officer may be a good man, but since he is collecting evidence for the prosecution and against the accused, he is an interested person. He is bound to go. He is bound to be prejudiced against the defense. He is bound to have entertained some kind of ulterior motives. कि इस आदमी को मैं फंसा के रखूंगा. इसने what he want to score good points in his service record. तो इसीलिए the legislature, parliament and judges are not trusting him with the capacity to record evidence, because he cannot discharge a judicial function. And because there are many police officers who are appointed executive magistrate. They are SCMs. You will also find them, many of them, they discharge the quasi-judicial powers. So person, even a collector is a SCM, a special executive magistrate, and they are also exercising powers under section 144, 145 of the CRPC. You know that we have seen that here, promulgation of the order. These are the people who are, they perform what you call the quasi-judicial powers and not judicial powers. इसीलिए they are not court. इसीलिए इसका मतलब जान लीजिए आप, court definition. So I explained to you the meaning of fact. I won't again repeat it here. Even relevant and fact in issue भी हमने देख लिया कल का दिन, and even illustrations I have given you with regard to the fact and fact in issue. Fact in issues, they come under the provisions of Order 14 CPC and in CRPC 211 से लेके 219 तक, where the charges are framed, they are fact. Relevant fact, I told you, section 6 से लेकर section 51 of the Evidence Act 56 तक. In fact, rather, the connecting facts are mentioned here, which as a cross-examiner, you should know this. If you don't know the scheme of the provisions of section 6 से लेकर and section, the entire section here, I will say that till section 55, character evidence. The entire part 1 deals with the relevant fact. Please note that. So relevant fact are facts which are mentioned from section 6 से लेकर 55. Please by heart them and go through this section every day. 5 section पढ़ते रहिए. Get up in early in the morning, go through the entire 5 to 55. So all these relevant facts you are allowed to ask, because as a lawyer in cross-examination or examination chief, you can introduce only fact in issue. Cross-examination में scope है, even beyond pleadings you can go. In the examination chief, you must confine your case only to the fact in issue, which are mentioned in under the provisions of Order 14 of the CPC. And I mentioned to you issues are framed on the issue of law, in issue of fact, on the pleadings and the affidavit, on the interrogatory is mentioned, the court may examine witnesses. Similarly, the charges are framed by the court perusing the statement under section 164, 154 FIR, statement under 162, and also the statement under the provisions of section 164, confession, and admissions which are mentioned from section 18 से लेकर 23 of the Evidence Act. These are all covered here. Even interrogatories are covered here under the provisions of the Order 11 for the purpose of framing issues, and even the magistrate can do so following the provisions of section 294 of the CRPC. तो इंट्रोगेट वो सब हो गया अभी. वो करने के बाद the fact in issue is completed. Fact in issue के अंदर you can, but yeah, another interesting provision is that here, as a lawyer or a cross examiner, you can only ask questions which are relevant. Like somebody asked me a question and the question has passed. Can the magistrate or a civil judge use illegally collected evidence in the court proceeding? Yes, there are judgments to that effect here. There may be a ban, so you may take up the right to privilege case of Puttasami's case, but your fundamental rights are not absolute, because even evidence which is illegally collected to tape recording, आपके पीछे recording किया गया हुआ है, आपका टेलीफोन टैपिंग करते हैं लोग, विजिलेंस करते हैं. आजकल पेगासस का इश्यू बहुत चल रहा है, isn't it? Isn't it? Watergate का issue भी also, you all know that here. But whatever evidence which is illegally collected that is germane to the issue, the Evidence Act is permitting under the law. Even in England, it is permitted. Only in America, it is not. It is forbidden. That is called fruits of the poisonous trees. In several states of the USA, they are not allowing. Now, there is one interesting section which says that the magistrate and the judge can put any questions relevant or irrelevant to the persons, which you know that here. So you learn under section the definition, relevancy of fact in issue. Abhi, I mentioned to you that only the advocates, the examination chief may cross examination may, the question must be relevant, then only you ask the witness. Cross examination ke andar. But 165 check करेंगे power of Evidence Act के अंदर, which is the penalty last section, the penultimate section, which says that the judge may, in order to discover or to obtain proper proof of relevant fact, ask any question he pleases in any form, at any time, of any witnesses or the parties, at any fact, relevant or irrelevant. Underline the word irrelevant. Please note it. And may order the protection of a document thing, and neither party nor their agent shall be entitled to make any objection to any such question or order, nor without the leave of the court to cross-examine any witnesses given in reply to them, provided the judge must be based his fact declared by this act to be relevant and duly proved. So though the judge may call upon various witnesses, various partners, you produce document relevant, irrelevant. You may take up the plea that the accused, I was not in India. The court will say, you in America, London, वहां से document मंगाएगा, embassy को letter लिखेगा, वहां से मंगाएंगे, ये आदमी झूठ बोल रहा है, गलत बोल रहा है. So other side may take objection. How document relating to embassy, USA, America relevant? The judge may say that I would like to see whether your deposition is correct or not. The judge may call for the report of the commissioners who visited the property. The judge may will ask the neighbors, how is the conduct of this man? In some of the criminal proceeding, your character is relevant. He may examine your neighbors. So ये सब चीजें everybody will come and depose. The under 165, the court has vast powers. Even the document which are privileged documents, the magistrate and judges can call for it and peruse it. No witness can take up the plea that these are privileged documents. The husband and wife cannot take up the plea. These are privileged communication under 120, 122. We will not do it. Now the state of government of Union of India under section 123, 124 Evidence Act can take up the plea. These are related to the affairs of the state. Now they are privileged document. Not the advocate and the client can take up the plea under 125, 126 Evidence Act. These are privileged document. You are bound to disclose it to the learned judge. Under 165, his powers are infinite. Nobody can doubt the power of a magistrate or a judge who is recording evidence. But the proviso to section 165 clearly mandate that the learned judge, when basing his judgment, he should only consider the relevant facts and the fact in issue which are mentioned in section 5 and section 6 से लेकर 55 तक. Please note that here. It has very important connection which you should know that here. Why judgment must be based. See, provided that the judgment must be based on the facts declared by this act to be relevant. So declaration of the fact, the declaration in the Evidence Act that that certain facts are relevant are given from section 6 से लेकर 55. Underline करो word आप remember कीजिए आप, ये जानना जरूरी है. So the judge will only base his finding on the judgment, and if he bases his judgment out of the way, the judgment can be challenged. The judgment is not sustainable. You have a right to file an appeal under the order. Okay, ये समझ में आ गया आपको. Next topic for discussion today is a document. Now please आ जाइए. I'm going step by step and explaining to you.
Sir, I have one doubt.
हाँ बोलिए.
With regards to the powers, the powers with the husband and wife to not disclose the information. Sir, is I think it's mentioned in the Evidence Act only that if a husband commits any crime and tells his wife, she could not, she is like saved and protected under the Evidence Act to not disclose it in the court of law.
Yeah,
until
section
unless it's
122
something which
to the
involves both
counsel
of them.
to the opposite counsel you can take a plea. 122 के अंदर there's a bar. But when the court asks you the question, chamber में आके बताओ मेरे को, you have to disclose it. Huh? The court will call you a witness. The court will call a witness, maybe a husband and a wife. At that time, he will request the other side lawyer and the other side to please go out of the court. Please note, आप trial court में आके कभी देखिए आप, the many times the other lawyers are told to go outside, or sometimes the judge will call them in the chamber and discuss the matter. Sometimes any objection is raised with regard to the admissibility, privilege communication. A lawyer will take up the plea this not to answer in the open court. सबको मालूम पड़ जाएगा. So these are privilege communication. So judge क्या बोलेगा? All those people who are concerned with this matter may kindly go out. कभी भी आके देखिए आप ट्रायल कोर्ट में ये होता है normally. You as a young lawyer, when you are taking up a matter of your husband and wife, you may request the court. Some of the points your lordship has asked me are touching the privilege communication under 122 of the Evidence Act, which I would not like to divulge in the open court. I do not mind revealing to your lordship because your power under 165 are there. So this is a confidential communication. Other people should not come to know, and I will show the document to the court, and this may not be shown. तो अभी सुप्रीम कोर्ट में भी चेक करेंगे ना आपने, सील कवर में तो ये सब कुछ दीजिए. हाँ, पढ़े ना आपने, सील कवर इन एनवेलप पॉलिसी. हाँ, many of the Supreme Court judges कहते हैं, they right from the 2G, 3G, 4G cases में इतने लफड़े हुए देखे ना आप, माइनिंग केसेस के अंदर सुप्रीम कोर्ट की ये आदत हो चुकी है अभी. Tell the counsel you please give your facts and document in a seal envelope. Even Bofors cases and Rafale's cases, all these cases Supreme Court has been pleasing and they are not divulged. So they will keep in the safe custody of the court. वो किसी भी lawyer को और clients को other side को दिखाते नहीं. That is remember the provisions of section 122 से लेकर 126 of the Evidence Act when we discuss the privileged communication. Okay. These are, but court के लिए court has the full authority to go through. Even if the court takes up the plea that here this is a privileged document affair of the state, we cannot. The court has a right to give finding. In Sodhi's case, SS Sodhi versus State of Punjab, the Supreme Court has given the year 1961, where the justice, three judges, that is very eminent judges, Subbarao, Justice Subbarao and Chief Justice Gajendra Gatkar का judgment है. Beautiful judgment, go through that. Beautiful judgment. We'll discuss one day the judgment when I'm dealing with the privileged document. Okay. और कुछ पूछना है किसी को?
Yes, sir.
Yeah.
No, sir. Thank you, sir.
Yeah. Now document का definition check कर लो आप जरा. Now document means any matter expressed or described upon any substance by means of letters. तो कुछ भी जो लिखा गया letters में, letters mean it may be written in the notebook, it may be written in the textbook, or it is written in the type recorder, it may be printed form, figures, marks, or more than one of these mean intent to use, which may be used for the purpose of recording the matter. Inscription भी लिखाते हैं, पत्थर पे भी लिख देते हैं आप. हाँ, पुराने जमाने में आप जाइए गांव में, राजा महाराजा सब अपने नाम लिख देते हैं. मरने के बाद टूम के ऊपर लिखते हैं कि ये आदमी सो मर चुका है, ये साल में पैदा हुआ था, ये साल के अंदर. You notice that inscription. टेम्पल में जाके देखिए आप, लॉर्ड कृष्णा ये तारीख को ये हुआ था, महाभारत की युद्ध इतने साल की हुई थी. So these are all can be used. These are all documents under the law. When expert evidence is required to be led under section 13 of the Evidence Act or 45, ये सब चीजें काम आते हैं. Okay, ये documentary evidence document होता है, and the illustration given is this: map or a plan is a document. So map से बहुत सारी चीजें मालूम होती हैं, because in fact a map has been given a very high status where the court can take a judicial notice that the fact is true. That is section 57 check करो आप. Section 57 कहता है कि the court shall take a judicial notice. Notice it. All laws in India, then plans, then plan के बाद maps के बारे में check कर लीजिए है इधर. Specific section है इसके अंदर. किधर चेक कर बाद anybody can tell me exactly section 57 चेक करो, उसके अंदर है war के course of proceeding, accession, seal, all the seals of England's court, British court, seals, the accession, then existence of title, flags, then the division of time, geographical division, the territories, dominion, the continuation, termination of hostilities, members. All these are all court can take judicial notice. Even a map of India, a map of America, the world map, is the court will take a judicial notice. It is a correct one if it is produced. A particular ship was going in a particular direction. It caught and colluded. You may have filed a suit in REM, and that is called in cities like Bombay, Calcutta, Madras. The high courts have marine jurisdiction. What it is called? You know what is the jurisdiction? It is known as. Which is the jurisdiction? Anyone of you remind me?
Admiralty
Admiralty
jurisdiction.
jurisdiction.
Admiralty jurisdiction के अंदर मैंने judgment and decree is passed. It is a conclusive evidence. Admiralty के अंदर. So normally उसमें plan बताया जाता है, ये बताया जाता है कि ship was wreck हो गया क्या, ये direction में जा रही थी. So the court of law के अंदर those maps, those indication, world map, Indian map, वही बताएंगे आप. They are become admissible. No objection can be taken. Next item देखिए. An inscription of a metal plate or a stone is a document. किंग अशोका आप जाके देखिए, आप उनके जमाने में बहुत सारे इंस्क्रिप्शन हुए पत्थर के ऊपर, मूर्तियों के ऊपर. ये गॉडेस की मूर्ति है, ये सो गॉडेस के है, ये किंग ने ये लिखा था, हर्षवर्धन ने ये लिखा था, मौर्य ने ये लिखा था, अकबर ने ये लिखा था. Various kings, what they have inscribed in the tombs, these are all evidence with regard to show the correct date of birth. Maybe your forefather, there may be a dispute in the family with regard to your genealogy. Many people, after the death of the Raja and Maharaja, they file suits. Hey, we are the heirs. You know that if a Raja, Maharaja, उनके पास बहुत सी property होती है, जागीर होती है, isn't it?
Sir, sorry to interrupt you.
जी बोलिए.
As you said sir कि जो राजा महाराजों ने मतलब नाम वगैरह लिखे थे और it will be also considered as a document. So if we write any name on that stone, so it will be considered as forgery with that or what?
Forgery, it becomes only when that somebody has copied it with malified intention to use of the property. If something inscription is there on the stone for 100 years, 200 years, it's a matter of historical importance. अभी किंग अशोका ने कलिंग के अंदर जंग छोड़ दी because he did not like the idea of human beings being killed. He embraced Buddhism. Isn't it? तो उसमें बहुत सारे इंस्क्रिप्शन लिखे गए हैं. अब टेम्पल में कितने लिखे गए हैं, अच्छे बातें भी लिखे गए हैं, वार के बातें में खराब बातें. So to prove that a particular structure existed, a particular structure is a 1,000-year-old temple. Some trustees are fighting over the trusteeship of a particular temple. एक बोलेगा ये 1000 साल से, 2000 साल से, कोई बोलेगा हमारी फैमिली से generation to generation from time immemorial, only our family can become trustees and nobody else. Such a suit can be filed under section 9 for establishment of your civil rights. You know that here. तो उसके लिए वो प्रूव करेंगे whether such a document, ये जो आदमी कंटेंशन लिया है कि सदियों से ग्रैंडफादर, फोरफादर, फादर के फादर, फादर के फादर, from maybe 1,000 years, maybe he is a pujari of a Tirupati temple, a hereditary trusteeship हमको मिलेगी, तो he will prove it. So other people may take on record. अभी recently in Bihar के अंदर, Bihar and Gujarat, Bihar and UP के अंदर, many one Maharaja died and all. Hundreds of people file cases कि we are the children of the Maharaja, great father, great grandchildren. Thousands of crores of land, everything, because Raja Maharaja के पास है. Because under the one of the Maharaja last who expired in Bihar, he did not have children, I'm told. The judgment is reported. Several of them proved bogus genealogy produce किए. ट्रायल कोर्ट ने ऑर्डर पास कर दिया बिहार के अंदर, यस ये जियोलॉजी करेक्ट है, हाई कोर्ट ने भी एक्सेप्ट किया, बट द सुप्रीम कोर्ट के अंदर सेट असाइड किया गया, दिस इज ऑल फेक, these all fabricated document, as you rightly said, some of them. The court will examine it with the help of experts कि ये document को लेना है नहीं लेना है. So this document is a documentary evidence which you can prove as a secondary evidence or a primary evidence. Primary evidence को पत्थर को लाना पड़ेगा. The court will appoint a commissioner. Commissioner will go and take inspection. Under the provisions of Order 26, Rule 1 to 9, 10, inspection in commissioners are appointed. Under Order 39, Rule 7 also, court appoint commissioner. They will record. Report of the commissioner is a matter before the court. It becomes a part of the evidence. Because when I discuss with you, proved, disproved, not proved, while proving a document, while proving the case, disproving the case, what the court considers is not just evidence, primary evidence, secondary evidence, documentary evidence. Court considers the entire matter. Several matters, including, I told you, the report of a public, the report of a commissioner, the report of a bailiff of the court, the report of the old report of ancient some sage, some Chinese saint, कि इन्होंने क्या लिखा है इंस्क्रिप्शन के अंदर, पुरानी बुक में वेदास में क्या लिखा गया है, वो सब चीजें कोर्ट में आ सकते हैं. फॉर प्रूविंग ए कस्टम यू मे टेक अप द प्ली दैट एज यू टोल्ड यू देयर इज अ ईजमेंटरी राइट एग्जिस्ट टू गो टू द टेंपल फ्रॉम द लैंड ऑफ द डिफेंडेंट. द लैंड द डिफेंडेंट ग्रैंडफादर हैड अलाउड इट, फोरफादर, व्हिच इज ऑब्जेक्टिंग. वो बोलेगा नोबडी शुड कम अराउंड. You will file a public interest litigation in the court, district court. Okay, we have a easementary right to go to all villages to go and worship the deity. तो उसके लिए ये सब चीजें काम आते हैं, प्रूव करने के लिए such a custom existed, such a document existed, such particular inscription existed, such you can examine the oldest of the oldest person living in the town or the village or the pattas of from the village panchayat, inscription, stones में क्या लिखा गया है. Many of them have the habit of उस जमाने में लिखते थे स्टोन के ऊपर. सारी कहानी मालूम बड़े बड़े राजाओं की मालूम स्टोन्स के ऊपर है. संगमरमर के पत्थर के ऊपर लाके देखिए आप, राजस्थान वगैरह में लाके लोग लिख देते हैं पूरी हिस्ट्री कहानी. मेरी फैमिली में फोर फादर ये थे. So when a suit is filed for testamentary disposition, suit for administration, you don't know what the properties are. So you come to know from the inscription in the stone. ये सारी चीजें बोर्ड पे आते हैं. Okay. Then the caricature is a document. Caricature is a painter makes it caricature. Up Times of India में Lakshman writes it so many kind of slogans against the politician. A politician files a suit for defamation. वो caricature prepared is evidence under the law. वो बोलेंगे caricature नहीं बनाया गया. Like M.F. Hussain prepared the goddess के photos nude बताया गया, उनके खिलाफ proceeding हो चुके. That was used. Ultimately, he left India and went away. So his paintings are also a caricature. They become document under the law in the matter. So they can be used in the court of law for many purposes to prove that here, this is the ownership of Mr. XYZ. Some of the paintings are running into crores of rupees, millions of rupees. Somebody has stolen from your house and sold in the market for a cheaper rate. You must have bought it from Europe for 100 crores. और मे बी 1 करोड़ 2 करोड़. योर नेबर आपको ट्रस्ट करके चाबी दी, किसी के आगे बेच दिया उसने 1 लाख में 2 लाख में. So you filed a complaint, then you prove it. These are the caricature. This is prepared by so and so painter. I got so and so proof. I went to London. यहाँ से लिया था मैंने. उस पेंटिंग के अंदर कैरिकेचर में ये लिखा हुआ है, इसमें गॉडेस है, so and so है, हाथी है, बैल है, whatever it is you mentioned. So these are all document on the eyes of law. The expression document is very wide. So document doesn't mean that only newspaper. Document doesn't mean just newspaper or a book, or it doesn't mean just what is mentioned in any of the letters, love letters. No, it can be many things. Caricature, map, inscription, बहुत सारी चीजें हैं. Okay. Anybody want to ask any question here? So this will come on documentary evidence, especially where documentary evidence under the Evidence Act is given under section 62 and 64. 62 tells you what is a primary evidence. Primary evidence is a original document. And section 64 tells you, section 62 tells you, primary evidence mean document itself produced in the inspection of the court. And how this document is introduced before the court of law, section 64 tells you, proof of document by primary evidence. Document must be proved by the primary evidence except in cases hereinafter mentioned. So you have a chance open to lead other evidence too, if you are not able to prove, if you are not in custody of the primary evidence. So document bolenge, this particular deed is prepared by my grandfather. I know his signature because as a child I used to play and he has signed scribble in my notebook. He used to pass comments on me. I'm a good boy, bad boy, so and so. These are, I remember. I also have his passport. I have his document. I can see that this is my grandfather used to sign the checks before me. I remember recognize his signature. This is the original document. There is one way it is proved. It can also be proved through the accountant. Yes, in my present, the grandfather of the plaintiff used to sign it, the checks. I know, I remember his signature. Or secretary can give, typist can give, juniors who can give, a senior lawyer's assistant can give. You know, a Supreme Court judge who has prepared so many judgment documents, his secretary can tell, yes, this is a signature of his lordship. So that is how it is a documentary evidence tendered. अगर वो आपके पास original नहीं है, for A reason, B reason, mutilated, destroy हो गया, then you are allowed to lead secondary evidence under section 63 and 65. Those circumstances will tell you. That is how the evidence is laid. That is the meaning of a document. Now see, the next definition is evidence. Anybody want to ask me any question on document? Please go ahead before I turn to the meaning of evidence under the Evidence Act. पूछना है किसी को? पूछ लीजिए.
Sir, pen drive having important information, so that pen drive will be called as document or not?
Yes, a pen drive is an electronic record. It's an electronic record which is to be proved under section 65A and 65B. अगर खुद आप अपने हाथ से बना के रखे हैं, it is 65A, entire document original हो जाएगा. अगर आप पेन ड्राइव बना के इसके कॉपी बना के एक दूसरे को रखे हैं, that is secondary evidence which you are required to obtain a certificate under 65B subclause 4 from the authorities. It is a document. It is 100% a document. Pen drive is a document containing is a original document, primary as well as a secondary evidence. It's electronic evidence. Please note that section 57 tells you 59. You cannot give the contents of electronic record by oral evidence. Read the section 59. All fact except the contents of a document or electronic record may be proved by oral evidence. So oral evidence, you can lead a person who has seen, heard everything except the oral document. Document because documents speak for itself. And pen drive is a document. It may come in the primary or secondary. It's a document speaks for itself. When the document is on record, you need not give explanation to the court. The document speaks for itself. So that is why section 59 tells you you cannot give direct evidence. So direct evidence is given oral evidence under section 60. A person who sees it, who heard it, shouting, देखो मैंने देखा, A was killing B, I have seen. A was wearing a black coat at the time. B was wearing a white shirt. He has seen it. I heard him say, the children of my neighbor were shouting that my father was strangulating my mother. आवाजें आई, as a neighbor you heard it. So that is also oral evidence. Though it's a hearsay evidence become admissible under section 6, मैं बताता हूँ. So it's a oral evidence which can be or direct evidence, which is called under the Evidence Act, oral or direct evidence, best evidence rules. When a witness who has seen, normally if reliable, would not tell lies. A dying declaration of a person dying with regard to circumstances of a death, a man on the deathbed will not tell lies. झूठ नहीं बोलेगा. I was killed by my neighbor for A reason, B reason. मैं मरने का ये इलाज है. Hospital में doctor is giving operation to you. He will ask you, कैसे accident हुआ? मुझे आके कोई कार ने ठोक दिया, रिक्शे ने ठोक दिया, मेरा friend who has an enmity against me, neighbor कर दिया, उसने मार दिया. Because the law presumes that a man on the deathbed would tell the fact. That is how the presumption is attached to, sanctity is attached to a dead man's statement. On the deathbed, nobody tells lies. Something, that is a presumption. Unless you have a right to, you can rebut it. There is no, of course, you have a right to rebut it. You can say that your statement has been fabricated. These are planted, and he never made such a statement. I have contrary evidence to show that here, which he made differently before the different authorities. I have other evidence. You have a right to call evidence in rebuttal. Rebuttal का मतलब ये झूठ साबित करें. ये evidence जो क्या, it is not a, he is not a paragon of virtue. This man, what he said, what he is speaking before the court of law is a bunch of lies, and I will prove it by cogent evidence, reliable evidence that here he has taken somersault several places. He cannot be believed as a witness. You have a right to give. Evidence Act gives you full opportunity to both the parties to lead evidences in both manners. Please note that, yeah. Evidence Act is not going to detain any of you anywhere in the matter. Yes. Okay, समझ गए ना अभी? So I am coming to the definition of evidence now. Evidence means and includes all statement which the court permits. Now, when does the court permit the statement? Number one, one minute, somebody is calling me. I will not take his call. I will tell him that I will call him later. You all can hear me now? Hello?
Yes, sir. Yes, sir.
Yes,
You are audible.
sorry. What was I stating?
Sir, you were doing the definition of Evidence Act.
No, an evidence here, ना? What topic are we discussing right now? क्या example दिया मैंने आपको? What is the example I gave you right now? Somebody
Sir, you
distracted.
were discussing permission from the court to record the evidence, like when
Yes.
evidence.
So evidence means
permits
how the statements which the court permits. Statement of a person is permitted while in examination in chief under section 137 पढ़ लीजिए आप, of the Evidence Act 37, examination chief, cross-examination and re-examination. These are the three times. Section 137, examination chief, which is also dealt under the provisions of Order 18, Rule 4 CPC. Okay, this is one occasion where the court is permitting your statement to be recorded. Criminal law के अंदर you have to go in the box to record. अभी CPC के अंदर file the affidavit. But you cannot direct the civil court. The court may tell the co-parties, I am interested in recording your evidence in person, not filing of your affidavit. The court has the discretion. Filing of an affidavit under Order 4 is not compulsory. It's discretionary. The court may revoke the permission. Court would like to see your demeanor. That watch your conduct. Find out whether the veracity of your statement आप झूठ बोल रहे हैं या सच बोल रहे हैं. So 137 के अंदर एग्जामिनेशन चीफ होएगा और उसी विटनेस का, suppose you are a plaintiff, you are leading your examination chief. I am the defendant, I lead my examination chief. After leading the examination chief is led on fact in issue under section 5, read with order 14 of the CPC and order 5 and section 211 to 19 of the CRPC. वो evidence in chief हो गया आपका. So other side lawyer will cross-examine. Okay, that means in examination chief, normally why it is led? Anybody know? Tell me. Why you lead examination chief as a plaintiff or as a defendant? You lead examination chief to prove your fact, to prove your case. Okay? To prove your case. That is the meaning. Next topic will be proved, disproved, not proved. So you as a plaintiff is interested in proving your fact, namely, you have filed a suit for a declaration that you are a owner of the property and declaration that the defendant is a rank trespasser. and declaration that the sale deed is sham, colorable, bogus be set aside. So ये तीन आपके declaration है. That this honorable court be pleased to declare that I am the owner. That this honorable court be pleased to declare that defendant has no right, title, interest in the trespasser. That this honorable, he has produced a document, defendant ne, claiming ownership right. This is a bogus document, sham document. This honorable court be pleased to set aside the document. So you are leading this evidence. Court is permitting you examination chief. So you are allowed, the court is allowing this statement with a view to prove your case. आपको allow करेगा ये? So the statement this court is permitting. Now the order with regard to the proving an admission document 136 में आएगा. See, just to decide as to admissibility of evidence. So जो आपने document produce किया है, evidence produce किया है, ये admissible है नहीं है? Relevancy is another thing. पहले admit तो करें, admit हो सकता है क्या है? So the court will give a finding under 136 of the Evidence Act. वो देख लीजिए आप. Again order 13 भी आएगा इसमें CPC के अंदर. Order 13 में भी court में see whether the document को reject करूं, accept करूं. आपके पास CPC रहेगा तो check करें. अभी मैं CPC नहीं लाया हूं इधर. So order 19 के अंदर है वो provision. Order 13 के अंदर. Order 13 rule 1 and 2, 3 and 4 में check किए. The court to accept the document, reject the document हो दिया गया. So 136 के अंदर ये court will decide whether to accept this statement or not. Whether the evidence which is leading this gentleman, whether has he stated this fact in his plain or written statement or any letters. Then only if you are a plaintiff, you are in the box, or a defendant, if you are examination chief, the court will permit only those statements provided you have mentioned in your pleading and the court has framed a specific issue. If the issue before the court is whether the defendant is a trespasser or not, you cannot lead evidence that he was a mortgagee under the Transfer of Property Act. You cannot lead evidence that the adverse possession हुआ इसके अंदर करके. समझे ना आप ये evidence जो issue frame किया है court के अंदर उसी issue के अंदर. First of all, issue whether you are a owner of the property. What evidence the court will expect from you? Number one, you prove your 7/12 उतारा. You prove your sale deed. आपने ये प्रॉपर्टी कहां से ली थी? Show your consideration. Registered document produce करेंगे will be admitted. A registered document, if you produce sale deed, the court will say that under the Indian Registration Act, the court will presume that a registered document is presumed to be correct. A document which is 90-year-old is presumed to be correct again, 30-year-old document. Section 90 of the Evidence Act. So connect करेगा उसके अंदर. The court will say that yes, this statement I can accept and document I can admit. Under section 136 of the Evidence Act, the court will say yes, the defendant ने objection raise किया है ये question के ऊपर, but I reject the objection. The question is allowed. The plaintiff or defendant is permitted to depose his evidence. Because it is objection which should be recorded. If he is introducing a document which is not disclosed, you will say that I am introducing a document which is against you. My lord, this document he has not disclosed in the list of documents. Nor he has disclosed it at the time he is filing affidavit under the provisions of Order 11 Rule 13 CPC. अगर ये document disclose नहीं करेंगे, court बोलेगी you take the leave of the court. If the court will see document relevant है, irrelevant है. We will ask the question to you as a counsel. Please explain to the court how the document is relevant. Court is normally very benevolent, generous. Even at the stage of recording evidence, the court will say, give application, give a sufficient reason why the document is relevant, number one, and seek prayer from the court for permission to allow it. So under the provisions of Order 7, Rule 14, Subclause 2, the court can get leave. With the leave of the court, you can file the document. If you are plaintiff, then under Order 8, Rule 1A, Subclause 2, आप check करेंगे CPC में, with the leave of the court, the court can accept. Then again under the provisions of Order 11 में check करें आप, Order 13 के अंदर, with the leave of the court, documents can be taken on record. You may take up the plea through oversight. I have not produced the document. The document has subsequently come into possession by virtue of the amendment. I forgot to introduce it in the plain or written statement. This honorable court be pleased to allow me to tender it with the relevant document. So the court may allow these statements, permit or requires to be made before it by witnesses in relation to matters of fact under inquiry. So either you may produce a document, ये बोलेंगे, a particular document registration deed of the partnership is not with me, it is with my partner against whom I filed the suit. So I given him notice to produce. Notice to produce कर देना पड़ेगा आपको. So under the provisions of the Evidence Act, you have a right to give a notice to other party to produce the document. That provision I am pointing out to you, which is an important section, which all of you should know that both under the provisions of notice provision section 65 in the case of documentary evidence, where 66 के अंदर you give notice. हम पढ़े last time. I won't again repeat you. Make a note of section 66 of the Evidence Act. When a person is not in custody of the primary document, and the primary document in the custody of XYZ, you can give a notice to him, calling upon him to produce the document. Then another section under the Evidence Act, production is 162, where the court gives notice to you, produce before the court of law. Then there is one more section under the Evidence Act with regard to notice, which I like to point out to you, is production. After 138 check करो आप, एक section है इसके अंदर, direction, cross examination, leading question. One witness may be compelled to answer. Yes. Can anybody point out to me? This is a notice to produce document. Question, formal statement, refreshing memory, refreshing document, right to produce. Yeah, section 162 is there. Witnesses someone to produce a document. That deals with the notice 162. Check करें आप. Yes. Then 163 के अंदर भी that discussion is there when you are called upon to produce a document on notice. 163 check करें आप. Giving as evidence of a document called and produced on notice. Remember this section, please. Very important as a young. And 165 is the power of the court to tell you to produce a document. Then under the CPC also, there is a provision for a direction to give documents, that is order 16. Order 16, remember कीजिए आप, उसमें provision है whether issuance of witness summons for giving evidence or to produce document. Similarly, CPC के अंदर order 5 rule 3 के अंदर भी है, the witness summons be issued to the witness for production of a document or to answer the claim. Remember कीजिए आप, CRPC के अंदर भी है, इसके अंदर issuing witness summons to the witness or a warrant under the provisions of the CRPC 87, and summons are issued under the provisions of 60 to 69 of the CRPC. So both are procedural laws in the matter here, where the court can do that. Okay. So evidence may all statements, you understood it here. At the stage of examination, chief cross-examination, the statements the court may allow it here, and the order with regard to accept or not to accept the document evidence is passed under 136 of the Evidence Act. Then number 2, Chakra, all documents including electronic record produced for inspection of the court. So all documents including, documents mean the document definition, primary evidence, secondary evidence, electronic record, which is now mentioned. Electronic record is mentioned here under the Evidence Act. वो document में आ चुका है अभी, आप देख लीजिए यहाँ पे. When you see the definition, certifying authority documents में the expression certifying authority electronic record, electronic signature, electronic record यहाँ पे आ चुका है. After the definition of not proved, you should remember this. So these are also the statements which the court permits under section 59, 60, 64 and 62 of the Evidence Act. Please remember the relevant section. This evidence a connecting section where the evidence is tendered before the court. Section 59, 60, 60, 62, 64, 63 and 65, secondary evidence. Okay, direct evidence is section 60, best evidence. 59, you are not permitted to lead electronic evidence and other document, but other evidence can be proved. So यहाँ पे सीख गए आपने. Yes, all document. Anybody want to ask any question? We have concluded this evidence chapter. If the time permits, I will take proved, disproved, not proved. What is the time, Kumar? बताइए.
Sir, it's 8 p.m., but we can finish the interpretation clause today only.
Interpretation clause.
No one has any
नहीं,
objection to
पूरा
it.
शब्द पूरा नहीं कर पाएंगे. I will take one definition of proved. I can take proved, disproved, not proved. Okay. Anybody has any question in evidence? किसी पूछना है evidence में अभी? नहीं. Now next is check important. Proved, disproved, not proved. Very important. A fact is said to be proved. So at the time when the issues are framed by the court, issue is framed, does the plaintiff prove that he is entitled to for a declaration? So that means the plaintiff has to prove. Does the defendant prove that the suit is barred by limitation? So the defendant has to prove that. Does the defendant disprove that? The plaintiff is not the owner, he is a trespasser. He has to disprove, he has to lead evidence. So the onus is shifting upon him. He is only a licensee, or he is only a tenant, or he is only a gratuitous licensee. So the onus will shift upon him. Then not proved, agar dono evidence nahi. Let us see what is the requirement of proved, disproved, not proved. Now, court kya karti hai iske andar? What are the requirements? And while considering proved, a fact is said to be proved when after considering the matters before it, underline the word. It is not saying evidence before it. It is saying the expression matters before it. Because the expression matters before it is wider than evidence. The definition of evidence document is very limited. Only 4 items mentioned kiya gaya. Documentary evidence, secondary evidence, writing of a document, maps, inscription, caricature. 5-6 चीजें दिया गया. But it doesn't say the statements which are recorded by the commissioner appointed by the court. So you learned under the CPC, court has power to appoint a commissioner or report the commissioner. You taken up the plea that the building is in a dilapidated condition. Plaintiff will say that I need to demolish it as per the orders of the corporation. Defendant bolega different building is in a safe condition. So to determine the status of the building, the court will appoint a commissioner, a structural engineer. So uska report is not evidence here. It doesn't come. It comes under the definition called matters before the court. Underline the word. So writ of summons which have been served by the plaintiff upon the defendant under order 5 CPC, whether the issue before the court, written statement nahi file kiya, the decree ho gayi. So decree ho gayi and defendant has been evicted under the provision of order 21 rule 35. So बाद में defendant who was abroad came to know his house has been broken open by somebody. Then he lodged a complaint. Then he came to know the court में suit filed था against him. A decree has been passed. Oh, बाद में he like engage you as a lawyer. तुम क्या करोगे? You will first go and check on the record. What is how the bailiff was executed, how the decree was executed. Paper चिटकाए होंगे. Mean the summons were affixed on the outer door of the door. पुलिस स्टेशन में मालूम करेंगे, पुलिस भी आई थी, पुलिस बोलेगा the court had directed the bailiff to give assistant of the police, तो पुलिस गई थी. तो सूट नंबर पहली बार आपको मिला एज ए लॉयर, तो you will make immediately an application to the court to provide inspection of the entire record. पहले inspection लीजिए आप. Don't prepare a case like this. Please note that. You will go to the record department of the court, execution department में, write to the registrar, Protonotary High Court Bombay, or registrar of the district court, city civil court, whichever court it is, pass a degree. Be pleased to, I am concerned for my client, the defendant in the matter, against whom the decree has been executed, warrant of possession executed, possession taken behind his back. He had no knowledge. He had not been served writ of summons. So I would like to take steps to set aside the decree. So please provide me inspection of the document. So you will give notice to other side lawyer. So please note that I am taking inspection tomorrow on so and so time. You may remain present with so present. वो remain करना पड़ेगा. वो लेने के बाद आपको मालूम पड़ेगा, पहले चेक करेंगे प्लेन का भी फाइल हुआ है. नंबर 2, क्या steps लिया गया है? What is the suit for? Whether summons was served or not. You come to know summons were not served upon you directly. There is a publication in the newspaper. There is a report of the bailiff. The house was locked or papers were sent by registered AD. Somebody has received on your behalf and you're in your name. तुम बोलेगे, I was not in India. This is not my signature. The plaintiff has manipulated my signature. So I want to examine the postmaster. So immediately, because if you don't examine the postmaster, you take out application immediately. क्या करेंगे आप? Under Order 9, Rule 13 CPC, you make an application for setting aside the decree. So the report, the entire certified record is a matter before the court. Please note that certified copy of the record is a matter. You want to lead evidence. You want to examine the bailiff. You want to lead your evidence. That here the court will tell you. You prove by affidavit that you are out of India. So this report, the summon procedure, the order passed for publication, ये सभी are matters before the court. So you can place it. Fraud has been played upon me, upon my client. ऐसा कोई सर्विस ही नहीं हुआ है. समझे ना? So the court is considering matters before it. It is not just the evidence. तुम्हारा के document के I am the owner, not owner. यहाँ बहुत सारी चीजें आ जाएंगे. So the expression matters before it. Court either believes it to exist. बोलेंगे whether the plaintiff, after filing the suit, has he taken effective step for service? Whether such a remedy existed, or considering the existence so probable, it is quite probable he has done it. When the defendant is out of India, it is quite probable he has not received it. The court may draw inference. And a prudent man ought, under circumstances of a particular case, to act upon the suppose exists. So the court will say that when this man was out of India, by no stretch of imagination, उसको service मिला होगा. Or he was in India, होने के बावजूद भी summons नहीं लिया. That means he must have deemed to have refused it. So the court will come to this kind of a finding. So which you as a lawyer, you have to prove before the court of law by to make the court, compel the court to consider these matters. So these matters may be directly connected or indirectly connected. They may be circumstantial evidence before the court of law. They may be presumptive evidence. Yes, of matters before the court. It's not just your plaintiff document, your document. The other connected documents. ये सब दिखाएंगे कोर्ट के पास आप. And say that the decree has been fraudulently obtained, is required to be set aside. So the court will consider the various documents. Then disproved में देखिए आप. Disproved means normally when the plaintiff wants to prove a case, he the owner, he will, in the examination chief, he will prove the document. The court will say, consider this matter. Why I am calling a defendant a trespasser? Because I don't have privity of contract with him. Number 1. I am the owner because I have a sale deed in my favor. And I have filed the suit within 12 years. ये भी दिखाना पड़ेगा आपको. Under Article 66, 67, अगर आप 12 years के अंदर suit नहीं file करेंगे, the defendant becomes the owner under Section 27 of the Limitation Act. Your right will be extinguished Please note that here. As a true owner, your right will go away. उसके लिए उस point पे, if you want judgment, you have to see the judgment of the three-bench judgment of the Supreme Court in Grewal's case. Judgment of Justice Arun Mishra and two other judges are given recently on the 27th of August 2019. वो check करें यहाँ पे. Grewal's case, very important judgment. उससे पहले they relied upon a judgment of the Supreme Court in Nair Society's case. The very beautiful judgment in Nair Society's case. The Supreme Court said, if the true owner does not take action against the trespasser within 12 years, the trespasser who is in possession for more 2 years, he becomes owner by adverse possession under Article 65 of the Limitation Act. Because he has been paying taxes, he is looking after. He is in hostile possession. You never took action against him. So he will lead evidence, the trespasser. Well, look here, I have document, I am paying taxes for more than 12 years. So what if I don't have title? मैं 25 साल से इधर हूँ. 25 साल में क्यों? Why has he not taken action? I am the real owner. He may even say that there was an oral agreement to purchase. He backed out. I paid him money in cash, which he had no receipt. I am in possession for 15-20 years. The reason why he has not taken action, because he know very well I paid him money. वो भी question लीजिए आप. You need evidence of your friends, your neighbors, or your broker. That is also a matter before the court. समझे ना? It's a matter before the court. The court is considering a wide range of evidence. Evidence plus something else is called matters before the court. So there's a very wide connotation here. It is like an ocean, like a situation. It is not like a small pond where you are seeking for. You are leading the entire evidence of the world which is relevant. The court will marshal it. वो court will give a finding under 136 of the Evidence Act. ये relevant है नहीं है, इसको produce करना नहीं. So the plaintiff will lead evidence to prove his case कि I am the owner. Defendant will disprove it by leading evidence कि I become owner by adverse possession. Different plaintiff has not taken action for 12 years. So he disproves the plaintiff case. His ownership right is gone under section 27 of the Limitation Act. पढ़ के देखो आप दोबारा Limitation Act. I think last year पढ़ चुके हैं आपने along with CPC, isn't it? दोबारा पढ़ लेना आप if you have forgotten. Section 27. Kumar, if you have got copy, read it and for everybody's sake. Section 27 होएगा. अगर दोनों parties इसमें evidence lead करेंगे, because you have to give the list of witnesses under Order 16 CPC, isn't it? Order 16 Rule 1 tells you both the parties must furnish the list of their witnesses. So you yourself examine. It is an art of a lawyer to decide whom to examine, whom not to examine. कौन से issue पे किसको prove करने का है, that only an experience can tell you in the court of law, and nothing else but experience. उसके लिए you should have conducted a lot of trials. You should have participated with many senior advocates and watched several trials and read a lot of judgments. Then only you come to know किसको examine करना है, किसको नहीं करने का. The defendant will take up the plea that I was insane. Then whether you have to examine a medical officer under the Indian Mental Health Act, वो भी जानना चाहिए. If you don't examine him, plaintiff will take up the plea that year. At the time when the property was sold to defendant, I was a minor. I was insane. I was an idiot. So to prove that fact, you must examine somebody, a competent doctor, a competent person to give evidence. Your statement cannot be believed by the court of law. Like similarly, when you take up the plea that there's a custom existing in the community that your adoption can be adopted in our family or in our family or custom or clan, even after the statutory period of 15 years, 21 years maybe allow karte. So custom prove karne ke liye you have to examine the senior most man in the locality. Then only you can prove. The court will say that after considering the matters before the court and the evidence of the senior most man in the community, and court will say that yes, this particular issue has been proved by the plaintiff. अगर आप examine नहीं करेंगे तो court क्या बोलेंगे? It's not proved. The fact is not proved when neither party proved nor disproved it. Neither plaintiff has led evidence, nor defendant has. दोनों चुपचाप रहे. So the court will say that not proved. As a result, the court will pass an order suit is dismissed for want of evidence. So merely filing a suit is not enough in civil law. You must substantiate your allegation in the plaint and in the statements and in the affidavit and in the letters, correspondence, all should be brought on record. Please note that. And as a good lawyer, in the cross-examination of the defendant, you must put up your own case. You must put up your own case after after contradicting him, after impeaching his credibility under section. उसके लिए you should know the provisions of Indian Evidence Act 145, 146, 153, 160. ये बहुत ही carefully पढ़ना पड़ेगा. Sometimes your own witness goes against you. Then you must tell the court, मेरा witness is going against me because he has been offered bribe by the other side. Representation of People's Act में होता ना है, Congress party, BJP party, शिवसेना party, A party, B party. I will not take the original name. बोलेंगे ये विटनेस तो मेरा था, पैसे खा के उसको जवाब दे रहा है. देन उसके लिए क्या करेंगे आप? प्रोविजन अंडर द एविडेंस एक्ट. माय ओन विटनेस हु रिकॉर्डेड ए स्टेटमेंट बिफोर द इलेक्शन ऑफिसर दैट bribe has taken place. Now he is turning turkey, that is he is taken a somersault and supporting the other side. He should be declared a hostile witness. Kya? Hostile witness, I may be given permission to cross-examine him. Then you put to him question that here, what about you? You attended my campaigns. This is your photograph. Do you agree that? वो हुआ ना ऐसा बहुत सारे जगह होता है कैंपेन में. आप देखेंगे वेरियस पार्टीज में. And now UP में you are following election. A is shifting from A party to B party, C party. Isn't it? ये हर जगह हो रहा है. Indian politics is nothing but a mockery of the election law. With great respect, we call it ourselves a greatest democracy, which is correct, but election system is all nothing but fraud. How parties are allowed to do trading, parties are defecting on another, paisa khate hain, idhar jate hain, which is transparent. The entire world must be laughing at us. We are laughing stock. How the parties are allowed to jump into other party and continue in West Bengal ke andar, a leader who part from contested election from a particular party, normally opposition leader is coming from the other side. उन्हीं के पार्टी का आदमी the opposition leader. It is not. It is only happening in India, isn't it? It's very unfortunate. It is not opposition. There is no opposition as such. If the opposition leader is from your own party, where is the opposition? Is it not mockery of democracy? Similarly, you are allowed to kind of trading. That is unfortunate. It is happening right from the time when Mrs. Indira Gandhi misused the machinery to win the election. Justice Khanna ka evidence padenge how Raj Narayan successfully fought it. I am not supporting any party, nor denigrating any party, because according to me, all parties are same. You all are old wine in the same new bottle. So I am not a fan of any particular party. According to me, you also should not take any party. You should be stand for which is just and right, which is legally correct. So legally correct proposition देखिए आप क्या हो रहा है. So यहाँ पे when your own witness is jumping to other party, which is happening in our democracy these days, you have a right to declare that witness a hostile witness. Then you can invoke the provisions of immediately section 154 of the Evidence Act. 154 says the court may in a discretion permit the person who calls a witness to put any question to him which might put in cross-examination by an adverse party. That means आपके खुद के witness को you are declaring him as your dushman, as opposite party, you cross-examine him. Isn't it? That is how the situation is. Normally, your own witness, what you lead is examination chief or re-examination, not cross-examination. But the beauty of the Evidence Act is that if your witness turned turkey, he goes against you for a reason, he is won over by the other side, you request the court that witness may be declared a hostile witness. He is called a hostile. He is hostile towards you, mean going against you, deposing against you. I may be permitted to deal with him by asking question to him in cross-examination. If you don't do that, you are not proving your case. Please note that you are not doing justice to your case. So your case stands disproved. Not proved, the court will dismiss your case. याद रखिए आप. आज के लिए इतना बस topic. I do not want to bore you too much. बताइए. Any questions? Any question anybody has? tomorrow we can come back to the same time, 5:30. Okay? Is it okay
Sure,
tomorrow?
sir.
Yeah. Okay. All the best and good night. Chalo, bye.
Good night, sir. Thank you.
Okay.
Thank you, sir.